On September 25th, 2024, a New York State Police FBI Joint Terrorism Task Force came to my home. They had a warrant issued under the New York State Red Flag Law. Under pressure to follow Governor Hochul's Executive Order 19, they lied to get it.
Question. The only evidence that you put in your petition are the social media posts which, as you sit here today, you cannot link to my client, correct? Answer, correct.
From my ERPO hearing, official transcript cross-examination of New York State Police investigator Russell Denny.
I understand in the climate that we are in, you're entitled to free speech.
New York State Courts Police and the United States Attorney's Office both concluded that statements allegedly made by me were deemed free speech from the FBI report used in the New York State Police investigation against me.
We're concerned because we know that you have a pistol permit. All right? So that's why we're here.
Did you just hear New York State Police Senior Investigator Wayne Mattice admit that I was being targeted because I have a pistol permit?
Question. So as you sit here today, you can't tell this court that you were aware of a link between my client, Mr. O'Connor, and these email addresses and social media screen names, correct? You don't know that? Answer. Percent knowledge, no. Question. Okay. And you conducted no other independent investigation into Mr. O'Connor yourself, correct? Answer. Just a criminal history and a criminal background check. Question. And those were negative, correct? Answer. Correct.
Then what were you doing in my family's home? Why was I tossed in a cell and exposed to human waste for 3 days? Our rights are on the line. The New York State Red Flag Law allows someone with no knowledge of or relationship to a person to file a request with the New York courts to enact a temporary emergency responsive protection order with no due process. The result is the immediate suspension of your Second Amendment rights before you've had your day in court. They use a definition from New York State's Mental Hygiene Code, Section 9.39, to determine if someone exhibits a likelihood to result in serious harm. 1. Substantial risk of physical harm to himself as manifested by threats of or attempts at suicide or serious bodily harm or other conduct demonstrating that he is dangerous to himself. Or 2. A substantial risk of physical harm to other persons as manifested by homicidal or other violent behavior by which others are placed in reasonable fear of serious physical harm. The definition goes on to state, the director shall cause to be entered upon the hospital records the name of the person or persons, if any, who have brought such a person to the hospital and the details of the circumstances leading to the hospitalization of such person. The director shall admit such person pursuant to the provisions of this section only if a staff physician of the hospital upon examination of such person finds that such person qualifies under the requirements of this section. The problem is that the determination of whether or not someone meets the criteria of that definition is required as written in New York State Mental Hygiene Code Section 9.39 to be made by a physician, not a police officer, not a judge. In the process of using Mental Hygiene Code Section 9.39 to remove New York State residents' constitutional rights, they are in fact violating the code in the way they are applying it.